Hi, I'm Stephen Bourke, Principal of Supersplitting. Welcome to our regular video for subscribers only. What I wanted to talk to you about in this video is UK pensions. You will occasionally come across a client who's got a UK pension entitlement, or you'll be acting for the spouse of a person who's got a UK pension entitlement. A bit about these entitlements in the UK. They accrue during working life in the UK, either in the public sector or the private sector, and are typically paid as pensions. There can be lump sums transferred into Australia, but this has got tax consequences, and I'll come to that shortly. If, as part of your strategy, you wanted to split the UK pension entitlement in the UK, you'll need to engage lawyers in the UK to do so. What you would obtain is either a pension sharing order, which splits the underlying entitlement and creates an entitlement for your client as a pension recipient in the UK. So that's a good clean break that you would able to be obtained immediately. In the alternative, you can obtain what's called an earmarking order, which operates a bit like our payment splitting orders. In other words, the pension is earmarked for a split when there's a payment to the pension recipient. But a note of caution, if you adopt this as part of your strategy, the fees for the lawyers in the UK can be quite expensive. So make sure that the value of the UK pension is proportionate so that you can obtain that order and the transaction cost is not too high. In my experience, I've found that the UK lawyers' fees can be £15,000 to £20,000 just to obtain the order. The second part of your strategy might be to move the superannuation or transfer it from the UK to Australia. This is where the tax consequences come in. If the superannuation is transferred in the first 6 months of residency, then it's all transferred tax-free. It forms part of what's called the non-concessional component, or what used to be called the undeducted contributions, and that's the tax-free part, or the non-concessional part, of the superannuation interest in Australia. However, if the UK pension recipient has been in Australia for some time, then there will be tax consequences. The tax is measured from the growth of the superannuation from the date of residency through to the date of transfer, and the amount of growth is taxed at the taxpayer's marginal rate. So if your client is a high income earner and is in the highest marginal tax rate, then tax will be levied at 46.5% on the transfer. That, as a transaction cost, can also be quite prohibitive. So be aware of the tax consequences if that's going to form part of your strategy. Finally, you might just simply want it taken into account. To do that, you'll need to put some evidence before the court about the value and the characteristics of this form of superannuation. You can obtain a report from the UK pension provider, and that will give you what's called the cash equivalent transfer value, or the CETV. Put that into evidence together with a report translating that into Australian dollars using the most recent exchange rate, and we found that the court accepts that as evidence of the value of that form of superannuation. To obtain a more comprehensive report, you should then put into evidence what the entitlement of the UK pension recipient would be, so that the court is aware of how much pension is going to be paid to that person when the pension entitlement crystallises. So don't ignore the UK pensions, but be aware of some of the traps. Obtaining orders in the UK can be expensive, transferring it into Australia can have tax consequences, so at the very least, make sure that you put into evidence something about the UK pension entitlement, including the cash equivalent transfer value and the entitlements of the pension recipient when they become entitled.